Buenos días.
Good morning, everyone. Thanks very much for the presentation words. First of all, I'd like to thank the organizers of this event for this convocation to unite me with all of you, leaders and activists for peace. Some of them are not here now, but the distinguished authorities from the justice area here in this wonderful country of Guatemala, distinguished personalities from the justice and from the American justice
Que estar acá presente.
and of Europe that are present here, excellencies and representatives of countries, diplomats that also honor us with their presence in this morning and all the auditorium, all the public in general. I'm sorry, Antoine, I'm going to speak in Spanish. Just
¿Ok? Gracias.
I'm going to speak in Spanish. My colleague already did it in English because I think this is one of the ways of speaking in a native language of people, wherever you go, to integrate. In order to integrate what the core aims for and what the effort for peace are precisely that, to integrate. The judge Antonio Mindua from the International Criminal Court, which preceded me in the use of word, has spoken much on the genesis of the court. Maybe, perhaps many of the things that were already said, I'm not going to repeat them, but simply I'm going to talk to you from an American point of view of justice, of criminal justice. The conference is called The Long Way from Nuremberg until the ICC because indeed the genesis of justice, which aims based on the idea that yes, there is a criminal accountability in the individual when big crimes are committed, which constitutes horrors, atrocities, deaths, massive attacks to civil population, systematic attacks in which it can be, sometimes the state can be involved, but also armed groups. When we say this, it's true, there has been a long way until consolidating the idea of the International Criminal Court. Once the Second World was concluded and once we saw the big horrors that were known there, like the genocides, the Jew Holocaust, the forced massive sterilization, the experiments in humans, humanity was choked. And it was this idea that which initially allowed in August 8, 1945, that the Charter of London was signed by the Allied countries, which is instituted with the Statute of Nuremberg, the one that was called the Military Tribunal of Nuremberg, to judge precisely these big atrocities that had been committed in Germany and in some other countries by big perpetrators that some of them acted in the name of the state, others acted in the name of parties or coalitions. The aim of the International Tribunal of Nuremberg, which was an ad hoc tribunal that was formed after the crimes had been committed, was of indicting and punishing the perpetrators of these crimes, crimes against peace, against humanity, and war crimes. Parallelly, and in that same time, also the Allies constituted in Tokyo, in the Far East, other tribunals, special tribunals, especially to judge Japanese leaders who were responsible also of big atrocities and violations of human rights during the Second World War. With all these precedents, what is clear is that for the first time, it was recognized that at international level, not only the states can be called to be accountable for these big atrocities, but it's also possible to indict the criminal responsibility, individual criminal responsibility to those that from the big statements of power directed and commanded to execute these big atrocities. From that moment, the international community lived moments of reflection in which they aimed to form or crystallize the idea a great criminal court that could have been united to the idea of United Nations, but enabling or making possible that these crimes could be punished. At that moment, that idea was not crystallized, but but the declaration of the Charter of the United Nations was given, and the International Declaration for Human Rights, the first one on June 26 of 1945, and the second one December 10 and 1948. Also, parallelly, the Convention for the Prevention and Sanction of the Crime of Genocide was signed, which aimed that the countries who signed it could agree on prosecuting these big atrocities that make part of genocide. The important thing is that the Tribunal of Nuremberg produced what was called the Principles of Nuremberg, which were a series of standards, of international standards for the judgment of this type of crimes and these types of responsibilities, which were quickly adopted by United Nations in their General Assembly in 1948,
Destaca precisamente
of which outstand precisely the principle that says that it does not matter, it is not of interest, the official capacity of the perpetrator, even though he's a chief of a state, a chief of a government. This is not an impairment for him to be accountable or to be taken to international tribunals to respond for these criminal conducts of crimes against humanity or war crimes.
esfuerzos
The efforts of nations continued. We wanted to, and even up to now, we're working on the idea of a crime code of international crimes. But political interests of nations and of the states, as mentioned, as Antonio Mindua mentioned, did not allow and haven't permit that to happen. But the 90s, dramatic realities took place in the Balkans, in Yugoslavia. Dramatic realities happened also in Africa, especially in Rwanda. This led the Security Council under the seventh chapter of the Charter of the United Nations to set tribunals, criminal tribunals, but ad hoc, special for a specific situation. First, the Tribunal for Yugoslavia, in charge of judging crimes, war crimes, crimes against humanity, genocides that took place in the former Yugoslavia since the year 91 until a date that back then the Security Council of United Nations reserved the right to determine when that jurisdiction would end. Also, the criminal tribunal was also formed to Rwanda that Judge Mindua mentioned a while ago. And what matters is that effectively these courts, these special courts, ad hoc, temporal courts, provisional courts, produced an important jurisprudency in this field, which allowed also to continue making it mature the idea of an international criminal court being independent and permanent. It is like this. How we come to the Conference of Plenipotentiaries of Rome from 1998, in which 60 states finally
acuerdo
achieve an agreement and they sign in that moment the Statute of Rome, which creates the International Criminal Court. But the difference with the prior experiences, international experiences, is that this court is in first place independent, is not subordinated nor to the United Nations nor to the Security Council. Of course, there are some bilateral agreements of mutual support, but it's not subordinated. It's permanent and independent. There's no time limit. It's permanent. is complementary because its jurisdiction is executed only when in the national jurisdictions or domestic jurisdictions, whether it's impossible to judge
o es
these serious crimes or is materially the judgments or the investigations are just in appearance or have been installed only just to achieve impunity, or
por sí mismos refiere
when the countries by themselves they refer a situation to the court to be investigated, or finally, and as an exception, when the Security Council of United Nations
bajo el cap
estimates under the seventh chapter of the Charter of the United Nations that because it's being affected that the security and the peace of world peace is affected, they have to refer the situation so that the international criminal court can take care of the investigation and the punishment,
ya
which were the cases of Libya and Sudan that Judge Midura just mentioned, which in the future, well, there's an example I'm going to mention. Everybody knows that there's a group of Latin American countries just referred precisely another state to the International Criminal Court to be investigated.
la Corte Penal Internacional
The ICC was conceived like this, and that's what really matters, that the judges and this court can be independent, that they only are subject to the law, to the statutes, only to the rule of law, international rule of law. Nelson Mandela, he remembered in the time when the Statue of Rome was signed that the horrors of humanity, the horrors of the inhumanity of the human beings towards other human beings, who knows, he would say, many of these horrors could have not happened or at least be minimized if there had been an international criminal court that worked effectively. With the creation of the International Criminal Court, the international community remembered in the preamble of the Statute of Rome that millions of children, women, and men have been victims of atrocities that challenge the imagination, that really deeply touch the consciousness of humanity, and that these serious crimes constitute certainly a threat for peace, security, and the well-being of humanity.
esta
It is like this that this International Criminal Court has been created with concrete purposes. The first, to put an end to impunity of the crimes and the atrocities of the most serious crimes and atrocities committed in the world, which has of transcendence for international community. Likewise, to grant compensation to victims as for access to justice, and also to contribute in a third instance to these acts to the prevention of future crimes and future atrocities of this nature.
los crímenes que la Corte Penal
The crimes that the International Criminal Court judges, the ones under their jurisdiction are four. The genocide, which is the one that is constituted when actions to destroy or disappear a human group are carried out, whether for ethnical reasons, political reasons, religious reasons, or any other type. The crimes against humanity, which are those murders, forced disappearances, tortures, or any others, massive and systematic, which are committed within the framework of attacks, generalized attacks towards civil society. This has to be this context so that they are understood as crimes against humanity. It is important to understand the context of this crime and their reality. War crimes constituted also by aggressions to human beings, murders, killings, tortures, and some others that are precisely given in the context of armed hostilities in a conflict wherein where this can be a national conflict or
nacional o
it can be an international or a non-international conflict. And finally, the crime of aggression, which has entered into validity recently now in December 2017. It was reserved for a long time. Its validity was reserved for a long time because it is referred to those crimes committed principally the chiefs of government or the leaders, the armed leaders that make use of force, illegitimate force against another country or against another political entity.
debo decir también
I must also say that the international community, recognizing the sovereignty of the member states of the criminal policy, decided something that's very important, to which I already mentioned before, that it should be the national authorities of the different countries, the ones that should first have jurisdiction over the things happening in their countries. And only when they cannot work, and then as a complementary forum, the ICC would come in. Like this, national jurisdiction have the preferent right of judging their nationals. In words of Kofi Annan, may he rest in peace, the creation of the International Criminal Court constituted a huge step in the path for universal human rights and the empire of law. Now, I'd like to talk to you a little bit about the contributions of the ICC for international justice and for the peace. The victims truly are in the middle of international justice, in the center of international justice. It was by checking the sufferings of that thousands of human beings have suffered. That's how we took a step ahead to form the International Criminal Court. That's why in the Statute of Rome there are many provisions to compensate the victims. Let us say that because of that, this court, it's not only a criminal court in charge of retributional justice, not only seeking for the punishment of the perpetrator, but also aims for the compensation of victims and also trying to compensate the damages that they have suffered.
Car-
It's important to highlight that the preamble of the Statute of Rome recognizes this fact, but there is even another provision which is of the highest importance, because given that the nature of the crimes that this court judges is not only of being serious atrocities and serious international crimes, but also as a base, they also constitute serious violations to human rights.
es que existe
It is for this reason that the Article 20.3 of the Statute of Rome exists, which states that when we interpret the law, or when we apply the law, the court should always be consistent to human rights that have been internationally recognized by the law and by the rule of law. Now I'm going to refer, this is the American point of view, to the types of victims, special victims to which the court is lately making the effort to compensate the damage that they have suffered and to work with them in a way that has never been done before. And that is the case, for example, of the so-called children soldiers, those that are below 15 years of age that are recruited by the armed groups and by some states that are below 15 years of age, and they get enlisted, and they prepare them, they're recruited, and they train them in the hostilities against their enemies. And as a consequence, these children not only suffer the horrors of war, but also they are utilized and objectivized for all kinds of activities, many of them sexual activities in some contexts.
La Corte ha tenido
The court has had the opportunity of referring to these cases concretely in the case of Luanga, in the situation of the Democratic Republic of Congo.
Juzgó a este
The tribunal that judged this leader of one of the groups in conflict, the first instance room, applied the provisions, the pertinent provisions according to the Agreement of Geneva and according to the Convention of Rights of the Children, by concluding that the children are particularly vulnerable and they require a privileged treatment in comparison to the rest of the population. The trauma that's potentially serious that can accompany the recruitment, including the separation of these children from their families and the interruption of their studies and the exposure to the environment, to violence and to terror, are factors that need to be considered within the procedures for the compensation of these children. It has also recognized that all measures, appropriate measures, should be taken to promote the physical recovery, psychological recovery, and the accommodating this child to society, developing programs for children soldiers that can guarantee their development of their personalities and talents. The case of Luanga hasn't finished. It's a young case. The case of Luanga, this subject of compensation is still being object of all a procedure of appealing in the appealing division to which I belong. We haven't still make a final plea. However, from America, because I am a Peruvian, I am an American. Yes, because we all who were born in this continent, we are Americans.
a esta
As contribution to this great task of the International Criminal Court, I want to ask that many of the concepts and the practices that from this continent have been carried out as for the treatment and the restitution of rights can be used to strengthen the work of the court. Like this, the Inter-American Court for Human Rights has developed the concept of the damage to what's so-called life project. The concept that was developed precisely starting from cases like the one against Peru, the case of Loaiza Damaya and Pantoral Ramirez, which also mainly refers to the loss of opportunities and real expectations that the person had before all the crimes committed against the person. And this is particularly important in the case of child soldiers, because how could we compensate a child soldier?
10
With money, 10, 15 years later given $100? Is that how you compensate the loss of the life expectation? No, that's not the way to do it.
haciendo grandes
I think we're making big advances in this sense. I have had a lot of receptivity from my colleagues. We're studying the way of integrating all these concepts in the pleas and the activities of the court.
La Corte
The court has also had and is having the possibility very soon of addressing problems and cases and compensation of victims about victims that almost nobody speaks of and have never been treated specifically, which is the case of the damage that is suffered,
víctimas de
the so-called victims of attacks because of gender, or also victims of sexual crimes, which mostly are women.
los niños,
Women, like children, are the most vulnerable victims of armed conflict, even of crimes against humanity.
pero en razón
They're sexually attacked, but because of their danger, which also entails discrimination, they're attacked because they're considered as to be less. Women, in the context of war crimes or crimes against humanity, they are objectivized. They are used to humiliate the enemy, to take revenge on the enemy, to change with ethnical positions, to interchange in ethnical communities like if they were objects. And then that's how a terrible situation ends, that not only the right to equality, to the non-discrimination is vulnerated completely, but also that they have been treated as things, making patent the loss of their dignity. That hasn't been easy to be addressed at the ICC. There have been some examples in other courts, like the court for Sierra Leone, and unfortunately, at the ICC, that problem could not be addressed because the case Bemba, which was a case that had that kind of crimes, in that case, the appealing room before me, before my arrival, they were dismissed before my arrival. So in this kind of cases with this type of crimes, in this case, when the police have to be aimed at restoring equality and empowering women, they should also take a look into that there is a loss of life project and a damage that has to be compensated in a different way than any other type of crime. I am receiving much comprehension in this subject, and I think we're going to advance on this matter. But the International Criminal Court has also made big advancements in the subject for collective victims. It had the opportunity of addressing, in the case of Al Mojavi, which was treated, it was about the destruction of historical goods in the work frame of an armed conflict in the community of Tongotu. There, the ICC ordered collective compensation, given that the loss of the protected buildings was failed by all the community as a whole. But also, they have had the opportunity in other cases of making indictions of what is, especially what is the victim of an individual or collective victims. Also, the Inter-American Criminal Court has big contributions in this sense, and I believe that the integration of both concepts is going to empower the work of this court, because there are cases in which it's possible to make individual compensation, but also to make collective compensation, because the damage that in the case in a massive violation or rape that has made a big impact in that community. Therefore, there's a necessity of also making collective compensation to a collective victim. One thing doesn't overlap the other. In this sense, we have advanced on that, and I'm surprised about this. But I think that the Inter-American Court for Human Rights has also empowered this. The fact that it is possible that together with compensations, economic compensations, also symbolic compensations should be done, including public excuses that we used to practice in Peru, from my experience, that here is done by the perpetrators. It was precisely the case of Almaji, who recorded a video apologizing to the victims. This place, Timbuktu, for having suffered the destruction of their common properties, historical properties, within the work frame of this conflict, armed conflict. It is this and many of the contributions that the International Criminal Court has already given to international justice. However, I'd like to remind here that this is a young court, 20 years of age. It's been since the Statute of Rome was signed, and the court has functions only for over 15 years now. These first 15 years have worked for the court to start its function, to use all its potentialities for the first time, and they have achieved it in part. But I think this is the moment for this court to start strengthening, to be more effective, to make its results more potent, so that we can really fulfill the commitment that is implicit in the preamble of the Statute of Rome of contributing to the peace and to the world's security. I'd like to tell you, in this case, that the court can do much still. To begin, it has to see, it has to turn, they have to turn and see the common law system of thinking that only this is a court that is only focused on the punishment of the perpetrators. It is true. It is hard to process or to put into trial these big leaders, the biggest responsible people on these crimes. But together with this battle against impunity, has to be together with all the subject of compensations and victim compensation that start like the American view says. It starts by the right to getting to know the truth. Investigations should not be closed without giving account to anybody, nor they should be done. Absolutions could be done seeing only the rights of the indicted. We have to see the victims because the justice of a case, like in any other national jurisdiction, doesn't only refer to the justice for the indicted. There has also have to be justice for the victims, and in this case, that was starting to impose the complete application that had already been initial in some cases of the 21.3 Statute of Rome, which mandatorily provides that always, when you interpret or when you apply the law, the general principles of the law, you have to be consistent with human rights, internationally recognized. And what is it to be consistent with human rights that have been internationally recognized? Being adequate to it, not to violate them, to potentialize them. All this is being consistent with human rights. I have had a lot of receptivity. In the last reunion of judges, we discussed this thing very much. I think that judges, from the deep of their awareness, they have started to see this subject with more interest.
Por otro lado,
On the other hand, I think that also an important aspect of the contributions that this court can still start to give to empower its efficiency and its power is to work in the subject of positive complementarity. This is a principle of the Statute of Rome, and it's referred to as many people have understood it before as the fact of waiting, sitting down, so that it should be a state, the one that refers the situation to the court,
fijemos si hay un problema para
or maybe that somebody looks and see, okay, there's a problem, let's go intervene. But that is from the negative instance. But I propose that the International Criminal Court can have an efficient action with positive complementarity, which means making it possible that they can come close to national jurisdiction, as it can be understood from the preamble of the Statute of Rome, to empower them, because it is the national jurisdictions the ones that in first place have the right and the obligation of judging their nationals. But how? The court has advanced much, but those knowledges, that wisdom, they have to bring this information to national jurisdictions. But at the time, and I say this as an American, the court can benefit much from the national experiences. The American continent is a continent that is rich in going through so many atrocities and having made so many efforts to judge, punish, and compensate these type of things. There we have the experience of Argentina, with the military juntas. We also have the experience of Chile with Pinochet, the experience of Peru, the armed conflict with terrorism with Sendero Luminoso, state terrorism. We have a president that have been judged and sentenced for serious violations to human rights and in prison. He had an absolution, but the Supreme Court revoked that. It was a political forgiveness that was not within legality. Peru advanced much in this. Not only the sentence in the case of Abimael Guzman and all the group of the head of Sendero Luminoso, where they advanced to consider that given the context, the terrorism crimes that were committed by the group Sendero Luminoso did not constitute terrorism crimes, but also constitute, given the context, crimes against humanity. And also, given the context, serious violations to international human right. And also, given the context, serious violations to the human beings. There wasn't anybody else there to respond. I'm not going to speak about the Guatemalan case, but what the wisdom with that the Supreme Court of Colombia has, one of their magistrates is here. All this wisdom, all this experience can improve the work of the court. And I'm proposing officially that the court, there should be a space to empower the Spanish language as a vehicle to make this positive complementarity back and forth between the courts of and also as a vehicle to empower the court. Thank you. Thank you.
Gracias.
Thank you. I'd like to say that this idea that was part of my campaign, I was elected just last year in December. I really feel it because if my humble person was able to think of being a judge of the court, not just because I spoke Spanish, I have been dedicated the last 15 years only to terrorism, serious violations of human rights and crimes against humanity, and the Peruvian laws were not enough to judge these cases. So I have to see the knowledge of the International Criminal Court and of other international tribunals. But how? Thanks to my parents, thanks to God, I had the opportunity since I was very little, and I learned Spanish, English, and French. But that's not the reality of my colleagues. My colleagues don't speak French, don't speak English. They would have never be able to reach the knowledge of that court. And why? Because the court, the International Criminal Court, and the Statute of Rome, in spite of declaring in its preamble Spanish is one of the languages of the court, and in spite of the Spanish being one of the most spoken languages in the world, this precept is not current in the court. There are no Spanish interpreters at the court. Here's a representative of registry of the court that when we interviewed him, because he's Spanish, Mr. Peralta Rosilla, and I was surprised that he being Spanish and I being Peruvian and we won't speak Spanish. I would have to interview him in English or French. But I was rebellious, and I did the half in English and the half in Spanish. And I say, okay, you have to figure it out and you have to find a way to understand it. You, the judges. Okay, those are some of the ideas in how we can empower the activity of this court. We have to integrate the peace. Peace is an integrating activity. This continent can do much for the court, and the court can do much for this continent. We have to integrate efforts. Language is a vehicle, a very potent one. As final conclusions, I would like to sustain now, as my colleague Mindua has done, that one of the fundamental pillars of an endurable and sustainable peace is justice, but not just is any kind of justice. The well done justice, well administered justice, the justice that beyond being punitive or compensative only, but also is a justice that compensates and restores. Because we have to include the perpetrator in anything that is related to compensating. If we really want to make a reality the objective of the preamble of the Statute of Rome of being good for peace, that this should be a justice that is good for peace. Justice being well administered, international justice being well done, is also one of the bases of the rule of law. Not only of the national rule of law, but also of the international rule of law. Because what else is justice if it's not harmony? When the rights of all the citizens are recognized, restored, put into validity, so that we can get that the community develops and empowers itself. That's what peace is, and that cannot be achieved under the vision that the Statute of Rome has if two things that I'm going to refer to are not complied. The Rome Statute foresaw that the International Criminal Court shouldn't have a police force and nor any kind of force to execute its mandate. Those to execute the mandates of the court are the states by the obligation of cooperation to which they have accepted when they have signed and ratified the Rome Statute. Cooperation for what? Cooperation to execute the mandates of arresting, cooperation for accepting victims and witnesses after they have declared before the court and it's dangerous for their lives to go back to their homes, to their places. Cooperation to receive maybe some people that have been sentenced that shouldn't be in Holland or in that they should go back to their countries, and for a series of activities. Cooperation to make possible that the court can have and do an effective work. But that cooperation of states, even it seems to be a lie. I mean, even it's signed in the Statute of Rome by the effective plenipotentiaries. Sometimes, many times in the practice, it doesn't take place. Just like my colleague Mindua remind us. So, the leaders for the peace, the activists for peace that in this morning are congregated here in this scenario, have a big task. They have a big work to do ahead to advocate in their countries, just like was asked by Judge Mindua, to advocate in your states, so that the cooperation labor can be effective in your countries. But also because it is not needed to be a member of the Assembly of State Members of the Rome Statute in order to cooperate with the court. Any country can do that. You have to sign a cooperation agreement. It is important because the court doesn't have military force nor police force to execute its mandates, and that's a big limitation. We depend on the world. We depend on the international community and of the countries so that the mandates of the Statute of Rome and of the ICC can be made possible. This is also related much with the subject of the universalization, which Judge Mindua just mentioned. They started being 160 countries members of the Statute of Rome. Today they are 123, but there's many more missing. Even those countries that seem to be impossible for them to be part of the International Criminal Court. Now here I'm going to also want to take part of your intervention, my dear Mindua, when you refer to this to the United States. We the judges, we're independent. We have nothing to do with political criteria, but I do want to remind some phrases that the president of our court, Nigerian Judge Chile Eboe Osuji, that he spoke recently in the General Assembly of United Nations. The victims, the world needs the United States to make the work more effective. I firmly believe, as we, the judges of the court, believe that the people of the United States doesn't want to be far from this court. I don't know if there's American citizens here, but I'll kindly ask you to advocate in your country because so that this country can come back to the court because it was at the genesis of this treaty. It was at the genesis of this court, and it was at the genesis itself of international justice because it was the United States, the one that made succeed all the processes of Nuremberg. So only thing that they have to do is come back. To end, I'd like to point out that peace is not achieved immediately. It's an everyday way, it's an everyday path, it's a step-by-step thing. And durable and sustainable peace has a just justice. And in that, I think all of us present here, we are all committed to that. The point, a universal man that say, the poet, Cesar Vallejo, in his poems, he would say when he would speak about the multiple problems of Peru, he would end his verse saying, "Oh, brothers, there's much to do." I want to paraphrase this morning that verse and to say that in the matter of justice, in the matter of democracy, in the matter of peace, there are brothers, there's still much to do. Let us do it together. Thank you very much.